Hello, my name is Ashley. Thank you all for joining us on today's highly anticipated webinar. This presentation by the Russo Law Group is Top 8 Changes in New York State's Power of Attorney Law. Now, before we begin, I would like to cover a few housekeeping items. To help minimize any audio distractions, we have muted your microphones. Please submit questions through the Q&A window provided on your Zoom toolbar. We may address them as we go along. We also save time at the end to address questions. If we can't get to yours, we will follow up with you after the program. We should be together today for about 45 minutes, but no longer than an hour. We created a PowerPoint for the program, which we are showing on the screen. We are also recording this and we will email you the slides and the video. Please complete the webinar survey. We always appreciate your feedback. You will access the survey from your web browser. It should open automatically when we end the session. Now, if anyone has questions about housekeeping, send me a message in the chat window. At this time, though, I will turn it over to our managing partner, Vincent Russo. Vincent is a nationally recognized speaker and author on elder law, special needs, and estate planning. He's a founding member, fellow, and fifth president of the National Academy of Elder Law Attorneys. He's also co-founder of the Teresa Alessandra Russo Foundation for Children with Special Needs. So welcome aboard, Vincent. Thank you for being here.
It's great to be here on this cutting edge program that we're having today on this new durable power of attorney statute. I'm very excited because I really like the changes that have been made in the statute. It's going to be a good thing for all of us. I'm thrilled also that co-presenting today will be my partner, Deanna Eble. She's a partner in the firm and a lead planner in our Garden City, Islandia, and Manhattan offices. So Deanna travels a lot. So you have your favorite sneakers, Deanna? Deanna is also very involved with the New York State Bar Association Elder Law and Special Needs section. So I'm thrilled. She's got the inside scoop on these 8 all-important changes in the new law. So thank you, Deanna, for joining us.
My pleasure.
I'll take a moment, just talk about our firm for a little bit. I established the firm back in 1985, and we have 4 offices: Garden City, Lido Beach, Islandia in Suffolk County, and Manhattan. And we're a boutique firm, totally focused on elder law, special needs, and estate planning, and trust and estate administration, guardianships, and Medicaid. So what we do day in and day out is help families. We help you deal with the day-to-day challenges that you face. If you need long-term care, or you want to minimize taxes, or plan to pass assets on to family members in a protective way. And so we're readily available at any time to assist you. And we know that often we get calls of individuals who are in crisis. And so we will meet you at home, we'll meet you in the hospital, the nursing home, we'll do whatever it takes. And now everybody's doing Zoom. So that's also another option. We do video conference meetings all the time. So today we're going to cover what is a power of attorney, what are the benefits of a durable power of attorney. So Deanna, on that one, the word durable sticks out, and I know you'll be talking about that. Then what do I need to know about the new power of attorney law? That'll be the section on the 8 changes. And then lastly, we'll end up with, if you have an existing power of attorney, do you need to revise it? And we'll talk about the situations where you're really going to want to get a new durable power of attorney on or after June 13th of this year. So let's start out with that basic question: what is a power of attorney? And so when we meet with clients, we often get in, we up front want to talk to them about what important legal documents should they have that impact their life. And basically there are two. There's financial decision-making and the power of attorney. And then there are healthcare directives, a healthcare proxy, and a living will. So today we're going to be talking about finances, assets, paying bills. So a power of attorney is a legal document that gives someone you choose the power to act in your place when it comes to your financial affairs. You don't give up the power to do what you want to do on a day-to-day. This is an enhancement. You're allowing someone else to step in. And we see this often as an important document if you're incapacitated or if you're in a hospital and temporarily out of commission, and someone needs to come in and take care of your bills, manage your assets. So, Deanna, that's that upfront question that I think everyone would want to know about, which is, okay, I heard about this power of attorney. It sounds like it's important, but what are the benefits of having that power of attorney?
So one of the biggest benefits of having a power of attorney is that even in a temporary circumstance, somebody can step in and handle your financial affairs. Like you're in a hospital, for example, and you can't pay your mortgage because you're not home to do it. Somebody could step in, go to the bank, and take care of those things for you. The durability portion of it also plays into that it's effective when it's signed. There's no waiting period for something to take effect. Once it's signed by you as the principal and somebody as the agent, then that agent can step in and handle those finances for you. And they can do everything from paying bills. They can manage your assets, dealing with your stocks and making sure your IRAs are taking the proper distributions that they may need to be taking for tax purposes. And most importantly, for what we see is crisis planning. So when somebody finds that a family member is either 1 foot in a rehab, 1 foot coming home to get home care, or even in a more severe situation where they're in a hospital heading to a nursing home, there's rules that we need to abide by in order to qualify for Medicaid. And a lot of times, in order to qualify for Medicaid, you have to adjust your assets and how they're held and manage things in that respect. And if you're in a hospital or a nursing home setting, sometimes you can't participate in that. So the power of attorney is crucial for crisis planning because it gives your family the opportunity to protect your assets that you've worked so hard for in that kind of scenario, so that you might be able to qualify for other benefits to help pay for your care.
So we've got 3 important benefits that Deanna's outlined: paying bills, managing assets, and crisis planning. I think we all today are thinking about let's get back to the normal. That's what we're hearing about. And hopefully we'll get there real soon. But we're also thinking about what did we learn from the COVID-19 pandemic? And so what we understand is so compelling in our office is that clients who had powers of attorney were in a much better position to deal with this issue of paying bills, managing assets, and crisis planning. If they came down with COVID, they had someone appointed who could step in and take care of things if they were temporarily in a hospital. And when we look at, a couple examples of that, managing assets, we saw what happened with the stock market. It went up and down like crazy. And so if there was no one there to step in and manage your portfolio, that could have cost a tremendous amount of money. And as Deanna mentioned, if you needed Medicaid, you got to have the right provisions in a power of attorney, and then you have to have the document appointing that agent to step in. So 3 really important benefits. Now we're going to get to the new rules. And why I said what I said up front about my excitement is that in 2009, we had a new power of attorney statute. And unfortunately, the changes made it very, very complicated for someone to know how to sign a power of attorney, where to initial. There were a number of different places, whether you needed witnesses or a notary. And then there were two parts to the document that were created. The second part being what's called the statutory gift writer. Very, very confusing. And so in 2010, a year later, the legislature in New York looked at this and said, well, let's try to clean this up. And here again, they didn't do a very good job. But I can tell you with this new statute that the cleanup has been done in the right way. And so we're going to really focus in on these 8 changes in the new power of attorney statute. So change number one, easier acceptance. Deanna, what's that about?
So in the power of attorney that you were just mentioning, there were rules that were very strict about how not only the font size of the document, but also the specific language in the document. So there was specific language to caution you, the person appointing somebody, about what the document could do and what it meant to you. And there was also a section that very specifically spoke to the agents and their responsibilities. And the old power of attorney stated that you had to be word for word, especially in those 2 sections. And there was concern because some attorneys that were drafting their own forms, not using the form that the New York State Bar Association sends out, they weren't word for word, but they said the same thing. And so with so many people having their power of attorney not accepted by financial institutions, which created a lot of problems, there was a push to change that rule and say, well, if it is so very similar to what it should be, then we should still be able to accept it. And so this substantial conformance change is a great change, because by allowing for the language to be somewhat similar, it still has to be there, but it's somewhat similar, there's less rejections on those documents, which helps in any type of paying bills management and crisis planning to get those documents approved.
Yeah, this was a real problem for a lot of people. I'll give you an example of how ridiculous the prior law, hopefully I'm going to use the word was, if we were on June 13th or later. And that is, if in the statutory form you didn't bold certain words, or the font size wasn't the proper font size, in effect, you didn't have a statutory power of attorney.
Yeah.
And that could lead to it not being accepted.
And one of the
by
other,
third party.
right, and Vincent, one of the other things that people were doing is sometimes attorneys would say, oh, well, we're not going to use this section, we don't need a monitor, and they would take the language out. Or we didn't have successor agents and they would take their signature lines out, and then banks would say, well, it's not exactly the same, you have to leave that language in. And here there's nuances that are letting us take that language out, shorten the form, and still get it approved.
All right, let's go to change number 2. And this is one of the more significant of all the 8.
Correct.
More flexibility on signing. So Deanna, tell us about that.
So for me, I think that this is one of the major changes that's happening, and I'm actually very excited about this change because we do a lot of planning for individuals who have special needs, and there's sometimes a presumption that once someone turns 18, if they have certain diagnosis, they have to go for a guardianship and get someone appointed to handle their life, their finances, their health decisions, which isn't always the case. There are individuals who have special needs who are completely competent and can manage their own affairs. They just have limitations. And so for those individuals who are completely competent but have some physical limitations where, for example, they struggle to hold a pen and sign for themselves, or even have somebody hold their hand and sign with them, the law is now going to say that there's a clear procedure to direct someone to sign the power of attorney on their behalf. So they come into the office and they give us all the information about who they want to make their decisions if they can't financially make decisions for themselves. And then somebody can be directed to at the direction of that individual. Somebody can sign the power of attorney form on their behalf. It cannot be one of the witnesses, and it cannot be somebody who's related that may be entitled to a gift. But this opens the door so much more for people who have physical limitations but are mentally 100% there. It's going to be a huge adjustment for them, and a positive one at that.
Great. Let's move to change number 3, protection against fraud and undue influence. Now, this is what motivated the change back in 2009. There was a real concern that seniors and frail individuals might be taken advantage of, but they really made it overly complicated. So now we have a different approach to help combat any sort of fraud and undue influence. Deanna?
Right. So on the 2009-2010 form that Vincent, that you keep referencing, there was, as you mentioned earlier, a gifting rider. So the document itself only needed to be notarized, but if you included the gifting rider, the rider had a requirement for witnesses because we were expanding things. And the banking industry clearly had their concerns, because if someone just needs to have a document notarized, the concern was, well, what if they had a friend who, the document was signed and the friend just notarized it, but not really in anyone's presence, which is not legally allowed, but we all know those kinds of things sometimes happen. So by changing the law, in this change number 3, the law says that there have to be 2 witnesses to the person signing. So you as the principal have to sign it in front of 2 witnesses. And that way there's less opportunity for somebody to commit some kind of fraud. And from an undue influence standpoint, if one of the witnesses isn't comfortable with the situation because they feel the person is being forced to sign the document, if they're not willing to sign the document itself, the power of attorney is not going to be valid. And so that's how they're looking to fight against the fraud and undue influence on a power of attorney, because it's such an important document.
Yes, this is a good change.
Yes.
So we're going to move to change number 4, but I also want to remind the attendees that if they have any questions, they can post them in the question and answer on the website, on the webinar. So change number 4, this is really a clarification change in my mind.
Yes.
Healthcare management. Deanna?
So under the new power of attorney, the agent, which is the person handling the financial affairs, is now considered a personal representative for the purposes of healthcare financial matters. And what that means is the person handling the financial affairs is paying the medical bills, but they want to make sure that those medical bills are for services that were actually provided. And so logistically, someone else could be named to offer up medical decision-making for you under a healthcare proxy. And this clarification is just saying, well, even if I'm not named as the agent under the healthcare proxy, as the agent on the power of attorney, I'm still entitled to see the medical bill itemized so that I can clarify whether or not you actually had that test that you want me to, that the doctor wants me to pay for. And we don't have to worry about violating any privacy laws, because it's just the knowledge of whether or not something took place, so we can verify that the bill is legitimate.
Deanna, does this change eliminate the need for a healthcare proxy?
No, not at all, because the healthcare proxy is medical decision making. This is just as it pertains to paying the medical bills. So the financial side of medical, this power of attorney doesn't give you the authority to make medical decisions for someone. The healthcare proxy is still where that's going to happen.
So it's going to be important to have both a
Both.
power of attorney and a healthcare proxy. And we all often are recommending, along with the healthcare proxy, a living will and a HIPAA authorization. Let's go to change number 5. Has to do with gifting.
Okay, so gifting is one of those sensitive subjects because some people are some people get nervous at the idea of giving people the authority to transfer money out of their name. And for us, it's important to have gifting provisions because when someone's in crisis, for example, you want to be able to move whatever money needs to be moved, even if it's between husband and wife, you want to make sure you can move that money. So if you have a power of attorney and it was under the old laws that Vincent was talking about, 2009 or 10, and you didn't modify it at all, you were restricted, or the agent was restricted to making gifts of your assets total of $500 a year. That included gifts to charities, children, and everybody else in between. So if you do not modify the new power of attorney, they've increased the gifting threshold from 500 to 5,000 total in the year. But from what you can hear, our discussions and the examples we're using, we would also encourage that you add the modification section, which would allow for an unlimited gift in a circumstance that we can do crisis planning or tax planning or any other type of planning to help benefit your estate.
So you've expressed the concern that one might have about gifting, but I would ask you this question. If we don't have a gifting provision, and if someone becomes incapacitated and cannot manage their own financial affairs, and if they needed long-term care services and wanted to do Medicaid planning, what would happen, Deanna?
I'm actually doing this right now with a client. Mom did not have gifting in her power of attorney, and we are now spending a lot of time and money in court doing a guardianship because we need the judge to give us permission to make those gifts that have to be made in order to help deal with the medical expenses.
Yeah, so guardianships can be very expensive and time consuming. It could take a long time before a legal guardian gets appointed. And then you're subject to the court scrutiny. So having a provision that allows the agent to really protect your assets in your best interest, and that's a requirement under the statute, that the agent must always act according to your instructions. And if you don't have clear instructions, then it would be your best in what's in your best interest. So one of the keys is making sure you name an agent in the power of attorney that you trust, and have successor agents as well, because if you trust that person, you're really enabling them to help you if you need help. The other area that gifting would come into play would be estate tax planning, where it may be important to shift assets from one spouse to the other to minimize estate taxes, or to make gifts out of one's estate to avoid a New York State estate tax or the federal estate tax. So tax planning becomes important. And then the other place where gifting is important is when you want to fund a trust. And you might want to fund a trust for tax planning, for Medicaid asset protection planning, asset creditor protection planning. And so you would want to be able to have the agent authorized to be able to take assets out of your name and place them in a trust in a more protective way. Let's move to change number 6, which I really like.
Yes.
I like the idea that the statutory power of attorney is less confusing. Deanna, why is it less confusing?
So it's less confusing because it's now one complete document. And what we were seeing over the past 10 years or more is that the old document, the way it was created, it required you to include a third part to it in order to allow for things like modifying the gifts to be unlimited and a whole bunch of other scenarios, like dealing with creating trusts and dealing with Social Security and Medicare and Medicaid, and any other modifications that you were looking to do. You had to make sure that you knew in the first part of the document to initial a specific section, and then when you initialed it, you then had permission to add this gift rider, which just makes it completely confusing. And unfortunately, what we saw a lot from a planning standpoint is I would have people come in to go over their documents with us, and oftentimes you'd have a situation where somebody said, yes, I have a power of attorney, and they'd come in with the power of attorney, and you'd find that they had a power of attorney for somebody to just make payments and everything like that, but none of the modifications were added to the document because this last gift rider wasn't included. And it was confusing for attorneys, it was confusing for people in the community who were going on websites to try and do the documents themselves. And you had that situation that we were just discussing about guardianships, where in some circumstances, if the person, you come in, for example, about mom or dad, and you tell us that there's a power of attorney in place, and then this gifts rider wasn't included, you still could be in a situation where we have to do a guardianship to get anything done because it wasn't executed to its fullest. So by eliminating this need to add that third section and allowing for modifications to happen within the first part of the document itself, it creates a lot less confusion on the part of the people that are creating the document and drafting the document. And I also think from a consumer standpoint, it makes it less confusing for you to understand how everything flows and what provisions you're allowing and what authority you're giving people, because you need to understand whatever you're signing, you're giving people authority to step into your shoes and do stuff for you that you would have done for yourself. So that is a huge change to this document.
All right, so I have to say, Deanna, that your explanation of what you used to have to do under the existing law right now was very confusing. Your explanation was confusing, and it's not because you weren't accurate. It's just the law was so confusing.
Exactly.
And so I'm so happy that they've streamlined this. But I also want to just maybe supplement what you've said in your explanation, which is that when you have the statutory durable power of attorney, there's a form and there's a list of power provisions that go from A to O. And then there's what Deanna referred to as the modification section. And that modification section is where you can enhance your power of attorney with additional power provisions, or to clarify or expand from the list that's already in the printed form. And so you pick and choose whether you want the ones that are already in the document, in the form, and then you have the option to do the modification. So that's an important feature, that you just don't want to take a power of attorney off the shelf and get a form, off the internet, because that form is not going to have the modification provisions. It's going to have a section saying you can modify it, but it's not going to tell you how to modify it or what provisions are important to you to have in the document. And so that's where we come in, understanding your situation, and make sure that we give you the most robust power of attorney, always durable.
Right.
Again, Deanna, why durable?
It's effective when it's signed.
And if you become incapacitated, it remains effective.
Correct.
So if it's a non-durable power of attorney, if you become incapacitated, your power of attorney becomes voided. It's no longer available for the agent to make decisions. We in day-to-day world know that the reason to have a power of attorney is when you are incapacitated. And so if we go back a couple hundred years, the reason we had power of attorney statutes was strictly in the business world. I wanted you to go and name an agent to go buy some goods. But once you bought the goods, I didn't want that power of attorney to continue. So the statute is written that your power of attorney is only good while you have capacity, unless you make it durable. And so that's something we always do. We always make sure that your statutory power of attorney is a durable power of attorney. So I just want to emphasize that as we move on to change number 7.
I just want
there's
to
going to
add
be
one
some.
thing to that, Vincent.
Sure, go ahead.
Because it is, without the gifting writer, it is less confusing, but I just caution that even though it's less confusing, it does also have a number of sections that, like you were just referencing, need to be initialed or not initialed to make those modifications. And it's always better to do it under the supervision of an attorney, because you don't want to miss one of those initials and then find that what you thought was a robust power of attorney and that you had all the authority to do everything that you really wanted to do, because you missed one initial, you don't have any of it. And you and I have seen too many situations like that, really on the gifts writer, but just because they're eliminating the gifts writer doesn't mean that they're eliminating initialing sections to make sure the modifications are added. So I just emphasize it's always better to have an attorney working with you so that you make sure everything you want is there.
All right, let's move on to change number 7, which is going to create some work for the agent under the power of attorney.
Yeah, I don't know that it's going to create some work as much as help clarify some of what was expected previously. So the record keeping requirement, yes, it does require that an agent who's managing your finances keeps records of the transactions that they are doing for you, or even just receipts of things. You know, they're certainly not looking for the agent to suddenly be a bookkeeper, but they do want you to keep good receipts of everything you're doing, because you as the principal have the right to know what's going on and what somebody's doing with your finances. And in the interest of protecting the principal, we want to make sure that someone's keeping an eye. And if anyone ever questioned the agent on what they did and why they did it, they need to have good records for that. And so it's really a matter of making sure you keep records and track of everything that you're doing for the agent, so that if you're ever questioned as the agent, you have the ability to produce the documents and verify what you've done.
And this is something we recommended to the agents under the existing law.
Exactly.
To keep the records. That way, you're doing everything in a responsible way. You are a fiduciary. So you are taking on responsibilities under the law, and you have a duty to the principal, the person who signed the power of attorney, to do right by them, to act in their best interests is the terminology under the law. So keeping records is a very important aspect to this. So I'm glad now they've actually put it right into the statute.
Yeah, I think that's a big thing, because it clarifies for the agent exactly what is expected of them.
All right, so I'm going to do a little drum roll. Probably can't hear it because we're coming to change number 8. 8 of the 8 changes, financial institution acceptance. And this is what played into years of work on the legislation for this new statute and working it out with the banking industry in particular. So share with us, Deanna, the new rules that are coming in terms of financial institution acceptance.
Right. So you're right, Vincent. This new statute has been in the works for at least 5 years, if not longer. And one of the issues was the banking institution wanted to make sure that there were some protections for them also. So generally what was happening before hopefully Sunday is that someone would walk into a bank, say, I have power of attorney for mom or dad. The legal department would take the power of attorney and then oftentimes say, no, this isn't valid. It is too old. They'd have a list of reasons why they wouldn't accept it. And then that would cause delays for the individual, the agent who was trying to get things done. And so we recognized as a group in the elder law section that those delays can cause even more issues in a crisis, because delays mean that we don't get stuff done at the time frame that we need to. And so there's been a compromise, and that compromise is, generally speaking, if the power of attorney is properly signed under the law that it was created under, it's considered a valid power of attorney. It doesn't mean every power of attorney is going to be accepted, but the presumption is upfront, it's valid. And then the financial institution has 10 days from when they're given the power of attorney. They put a timeline that 10 days from receipt of that document, they can review that document. And in reviewing that document, if they find anything that is not valid, doesn't follow the law, doesn't meet the criteria that the law set out, they have 10 days to notify the principal and the agent of that refusal to accept the document. And these timelines were set in place so that the financial institutions can't just take their sweet time to get things done, because we're a lot of times using these documents for a time crunch. And the other concern that was out there is not only were the financial institutions taking forever to do things, there was no recourse. If they didn't accept the document and it caused delays, and it meant for example, someone had to privately pay for nursing home care because the document wasn't accepted in time, there was no damages that could be sought from the financial institution for their time delays and refusal to accept the document for a reason that wasn't a legitimate reason or one that could hold up. So if after 10 days and a back and forth with the principal and agent, the financial institution still refuses to accept the document, the principal and agent can take the financial institution to court. And if the court finds that their reasoning for not accepting the power of attorney is not a valid reason, then they can seek damages from the financial institution and also get awarded some attorney fees. And this was done with the expectation that more financial institutions will take this as serious as we all do and understand that there's some time restrictions on what we're doing, and not just say no to say no.
All right, so we've covered our 8 major changes on the power of attorney statute in New York.
Yes.
And
so now, Vincent, we've dealt with this power of attorney statute change. It's specific to New York. And now the burning question that everybody has is, now what? Now what do we do, especially if you have a power of attorney?
okay, so let's start with if you don't have a power of attorney.
Okay.
Hopefully, from listening to us today, you understand the benefits of having a power of attorney. And I would urge you to go out and hire an attorney to assist you with drafting that power of attorney and supervising the execution of the document. So I often think about the old American Express commercial, don't leave home without it. And we get that question, what age should I have a power of attorney? And quite frankly, anyone of legal age, 18 or older in New York, should have a New York statutory durable power of attorney. God forbid someone's in a car accident and they're laid up and decisions have to be made regarding assets or paying their bills or signing a tax return. There's no one with legal authority. The parents do not have legal authority over their child once that child reaches age 18. A spouse does not have the legal authority to make decisions for another spouse. And the law doesn't care if you've been married 40 years and you love each other to death. It's still not going to allow you to make those decisions. So, for example, if you owned property, a piece of property jointly, you need both signatures in order to sell that property, if that was the situation. So lots of examples we can give you about the durable power of attorney and the benefits of it. So we have this new law coming in. It's coming in on June 13th, next week. And so let's talk about how we go from here. First off, if you have an existing power of attorney, it will be grandfathered and still valid under the new law. So, so you don't have to be fearful that what you might have signed a year ago or a few years ago now is not going to be held as valid. Will it be the best power of attorney for you to have? Perhaps not, depending on what that power of attorney says, what powers you've given. And with some of these changes, we can see the practical side of utilizing the newer version, because it's going to be easier to provide a newer version, the new version, to a bank or a financial institution. They understand these new, more flexible rules regarding the wording in the document, the format. They're understanding of the fact that you can have someone else help you with the signing of the document. It's less confusing because we don't have that gift writer attached to it. So there are a good number of benefits that come out of having the newer version. But I want to make it clear, if you have an existing durable power of attorney, I would want to make sure it's durable. It will be grandfathered and valid under the new law. So let's talk a little about the reasons why to update a power of attorney that you have. One is, it's always good to review your estate plan. You know, in an ideal world, we would love our clients on the annual basis to have a follow-up meeting with us. And we have a program for those clients to make it more affordable, that we do an annual review and update, because there are always changes in the laws, changes in your personal situation, perhaps changes in your asset holdings. So one of the questions that comes up when you're looking at the reviewing your existing document is this: have you named the right people as your agent? And so it's a good time to check and still feel good about your appointment of the agent. And then the follow-up question, do you have successor agents? We feel it's so important to back up and have contingency plans in all of your estate planning documents. And in a power of attorney statute, this is really important. What happens if your agent passed away or is incapacitated? Who can step in? So it's always good if you have trustworthy family members or friends, or a professional that you feel comfortable that could step in and be that agent, and in particular the successor agent, then that would be a good change to make as an update. Deanna talked about these modification provisions: gifting, establishing trusts, crisis planning. So if you look at your power of attorney document and you feel like you're missing these important provisions, that would be a reason to update the document. Or if you're not clear about what the powers are being authorized to the agent, it's not clear to you what they can or can't do, that would be another indicator. At least have an attorney review your durable power of attorney, and that attorney can say, look, your power of attorney is fine, or no, there really is a need to update it. And then lastly, a concern that you may have, which is, I signed a power of attorney 20 years ago. I'll call that an old durable power of attorney. And there's always the concern about it not being accepted. So we have this new provision coming in that hopefully will help deal with acceptance. But I would say that you may want to update that power of attorney document that you executed a number of years ago. One, because if you update it with the newer form, that'll be more recognizable by the third party, the person at the bank, for example, and they'll be very familiar with the form. If they see a form that they're not familiar with, they're going to send it up to the legal department, and that's going to cause delays and add some stress in your life. And sometimes we get called in as attorneys to discuss with the legal department, and ultimately, in most cases, we get them to accept the power of attorney because it was valid and done correctly. Sometimes, though, we have clients who, prior to seeing us, had a power of attorney and then didn't update it with us, and then later have a problem, or they call us up in a crisis and they weren't a client before, and their power of attorney is faulty, and that does create problems. So I think at the very least, you should review your existing document. I would highly urge you to have an attorney review that document. And clearly, if you are hitting any of these reasons to update, then I would move forward and update the documents. And lastly, I would just say, this may sound so simplistic, but do you know where your document is? Not the copy, but the originals. Were
are
there
they
more
not
than
in
one
a-
original signed?
Right, and are they in a safe deposit box that we should maybe take them out of there?
Yeah. So that's the upfront. Sometimes clients say, well, we have these new clients come in. They say, well, I have these documents already, but then they don't know where they are, or they have copies of or they have the original and they wrote on it, which is something you shouldn't be doing with original documents.
Right.
So with that, I think we've covered the program. And so at this juncture, we do have a little bit of time, and we have a number of questions that we'll tackle. And I've got the list here, and the really hard questions I'm going to ask Deanna, and I'm going to take the easy ones. Okay, Deanna?
Sure.
All right. And so let's do a little of the Q&A, and then we'll circle back on how we can help you. All right. So I think we are the statutory changes only applicable to New York State?
Yes. Yes,
All
this
right.
is the New York statutory form, and these changes only pertain to the New York statutory power of attorney.
All right. So another question further down, if I signed a power of attorney in another state like Florida, will that power of attorney be valid in New York?
So it's always good to have documents for the state that you're living in. Some states will allow for you to use a power of attorney that's an out-of-state document as long as it was validly signed in that state at the time that it was executed. But it's always our recommendation, especially if you moved and you're now residing in a new state, to update your documents, or at least have an attorney in that state review them. Like, we had a client who moved to South Carolina, and the attorney there reviewed her New York documents, and all she had to do at that time was something with the county clerk for them to accept them in South Carolina. So it's always good to have them reviewed if you've moved, but in a crisis, if validly signed, they should be okay.
Yeah, so that was Danielle's question. And she has a family member out of state who did a power of attorney. They're going to be coming back to New York. She's in New York and needs to do Medicaid planning. So the answer, Danielle, is that yes, as long as that power of attorney has the right power provisions in it, then you're going to be able to do what you need to do up here. and also assuming it was properly executed under the laws of the other state. I got a question here from Eileen, who's asking, what course of action can we take if my parent is now in an assisted living facility with limited cognitive abilities, since she's filled out all this paperwork? So I think the last part means that the parent signed a durable power of attorney. So Deanna, just in the big picture, what can the agent do at that point? And I know we don't have the document in front of us.
Right. I was going to say, assuming that I mean, the agent can still use the power of attorney, even if it was signed under the old law, because if it was validly signed under the old law, it's still a valid document. And really, it's just a matter of how comprehensive is that power of attorney. And when you say limited cognitive abilities, just how limited are they? And it would be a discussion really about whether or not there's the ability to sign a new document if it was needed, if they didn't have a very comprehensive old document.
Okay, we have received a number of questions from clients. So we do have a number of clients listening in today. I just want to mention to them that we'll be doing another webinar exclusively for our clients on June 17th. And so if you're a client and have a particular question about your own situation, let us know or call our office or through the chat, and then we'll get the attorney involved who oversees your matter, and they'll get back to you. I did get a more technical question about the statute itself, and I'll just mention that it's New York General Obligation Law, Article 5, Title 15. So if you Google that, you would be able to get the statute. So I'm thinking an attorney is on one of the attendees looking for more information, perhaps.
Right. And Vincent, Lillian also mentioned that a lot of times banks often require that their own power of attorney form is signed. The change that imposes damages on financial institutions is essentially a response to the fact that many financial institutions say, no, your form isn't good, you need to sign ours. And so that is one of the pushes why that change happened.
Okay, and I think you addressed this, but Joe and Liz asked if they live in 2 states, do we need one for each? You only need one set, but
Right.
we would highly recommend that you do a set of advanced directives, power of attorney and healthcare directives in each state. And that way you would use the appropriate document, because the Floridians that you may be providing that document to may not be familiar with the New York form, or if you're using the power of attorney in New York with the Florida document, they may not be familiar with the Florida form. And that just creates delay. Often those documents going up to the legal department at the financial institution, or even a non-acceptance, which wouldn't be a good idea. So I'm going to ask you this question, Deanna. Julianne asked, please explain how to clarify when the principal directs someone else to sign on their behalf, how the signature line in notary is to be reflected for this purpose.
Okay.
That's
So it follows the signature line and notary follow the same guidelines that one would have for direction of signing a will. So it would say, basically, if I'm signing at Vincent's request, it would say Deanna for Vincent, and then the notary block would be me.
Okay. All right. Just looking at other questions we might be able to touch on before we wrap up today. Can you have more than one original power of attorney so the agent has one in their possession too? Or is this not advisable from a legal standpoint?
I mean, we usually do 2 originals in our office. So that when there's multiple agents, because many financial institutions want to see the original. And so we do generally 2 originals in our office.
Yeah, the key is though, that if at a later point you want to revoke your power of attorney, then you would want to destroy because let's say you're revoking it to replace it with a new one, or you just want to revoke it in a crisis situation for some reason, you do need to void those original documents. So if you had 2, you'd have to void both. And you would also want to notify any financial institutions that you have assets with that that power of attorney's been revoked. All right, those were really good questions, and there were a good number of others, but we've run out of time. So I want to just circle back to what can we do for you. And so we stand ready, willing and able to draft and supervise the execution of a new comprehensive durable power of attorney at a discounted rate. So we believe strongly in these documents being in the hands of every person 18 or older, and that they've taken steps to protect themselves. We typically charge $1,000 to do a robust, comprehensive, durable power of attorney, including the time we spend with families, the client, in terms of understanding the power provisions, decisions about who to name as the agent or successor agents, and then supervise the signing. But with this new change and our emphasis on making sure everybody is protected, we are going to offer a discounted fee if you have an existing power of attorney and would like to revise it to the new, under the new law. We're charging a fixed fee of $250. And if you don't have a power of attorney at all, then we would discount the fee from $1,000 to $450. So we're offering a very steep discount. There'll be a survey at the end, and you can let us know if you're interested, or you can contact us directly.
Vincent, can you just clarify, because I don't want people to misunderstand, but the person who has a power of attorney already in existence that they want to update, it doesn't have to be that we did the power of attorney. It can be that it was done by anybody.
That is correct. And we're also offering to our clients, if they're in the Peace of Mind program, then their document will be updated at no charge at all. And so that'll be an add-on benefit for our clients in our Peace of Mind program. So I'm just urging all of you who are listening in to, 1, have a durable power of attorney, 2, make sure it does what it needs to do in a comprehensive way, that you've named the right people in that document, and that if you have one already, take a look at it, review it, think about whether it should be updated, or get counsel, get an attorney. We're happy to look at it and let you know what we think. So with that, I'm going to turn it over to Ashley.
All right. In closing, I would like to thank Deanna and Vincent. Thank you for your presentation, sharing your knowledge and time with all of us, and of course, answering those questions. As always, we appreciate all of our attendees for joining us. If you could, please complete the survey. We are excited to read all of your reviews. Okay, everybody, be well and stay safe.
Have a nice day.
Thank you.
Bye.
Take care.